formal reading of the indictment.
Yes, Your Honor.
Ms. Kirkwood, in cause number 25 DCCR 0190, you're charged with the state jail felony offense of unauthorized use of a vehicle from January 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. Yes. And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Yes. Do you fully understand them? Yes. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Yes. And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Yes. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Kirkwood is not competent?
No, Your Honor.
Any history or any reason not to waive that pre-sentence report since it's in state jail? Yes. All right, then, Ms. Kirkwood, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow that agreement you made and defer all proceedings and place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you'll never have a felony conviction. The other side of that is if you violate any condition of your probation, you could be brought back into court, found guilty. So you would have the felony conviction and you could be sent to the state jail for up to 2 years. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Also, Ms. Kirkwood, especially on a state jail felony, if you do everything you're supposed to up front on that probation, get the community service hours done, make sure your fees are all paid up, there's no reason for you not to get off early. So it'll be up to you. You have to do it all right, but there's no reason for you to even have to do that whole 4 years if you get everything taken care of early. Okay. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. She's at that desk right over there. So listen for her to call your name. Okay. Good luck to you, ma'am. Yeah, take that. And let's see, Ms. Holmes, you've got Aaron Riley. Good morning. Are you Aaron Riley?
Yes, ma'am.
And this is 25 DCCR 1194. Ms. Riley's charged of assault of hospital personnel. And what is the announcement?
Your Honor, if we could have a little bit more time. Ms. Riley did provide me some documentation regarding her mental health status.
Okay.
This revolved around, that's why she was at the
Sure.
hospital that day, and I provided that documentation to the prosecutor. So we get some time to review that.
Sure. Any issues? All right, I'll just do a normal reset. Ms. Riley, make sure you stay in touch with Ms. Holmes and she'll let you know what she discusses with Mr. Smith and then when your next date is. Okay.
Okay.
You're free to go. And then Ms. Holmes, you've got Kaylin Thornton. Yes, sentencing.
Okay. Yes, ma'am.
This is Mr. Coleman's on Kaylin Thornton. Good morning, sir. You're Kaylin Thornton. And Mr. Thornton was previously in court in cause number 26 DCCR 0220, entered a plea of guilty to the 3rd-degree felony offense of promotion of prostitution. I have received the pre-sentence report and reviewed it. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
The only correction, Mr. Thornton is working now. He
Good.
works for IHOP and at Main Event.
Okay,
So I know he said he was unemployed, but he is working.
good. Good. Anything else?
Based on the PSI and the lack of criminal history, I know the agreement was for straight probation. We were inquiring as to whether the criminal would consider deferred.
Mr. Smith?
Judge, this isn't my case, but I would defer to your.
I mean, I typically, especially for job purposes, depending on the nature of the offense, give that opportunity. On a first, we've got no misdemeanor, no juvenile, no felony. It would make sense to me. Any issue?
I don't have an issue with it.
Okay.
Mr. Coleman might get mad at both of us, but
Well,
he's not here.
I can handle it. All right, sir, what I'm going to do then, based on that discussion is modify this to a pen deferred. All right, anything else then before I go forward with sentencing?
Oh, he has a GPS monitor on. He's been having it on for quite some time.
And that was a bond condition, so
Yeah.
that would be, I think, I won't require that unless there's some issues with probation. So he'll be able to get that off later today or tomorrow. And as long as everything else is going well, that shouldn't be an issue. I'll go through with all the conditions and make sure that's all understood. All right. Okay, so Mr. Thornton, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for a period of 10 years. There's Mr. Coleman.
As I was watching upstairs,
Go
I
ahead.
asked that the court reconsider, Judge. This, initially, there was an allegation of violence. I don't know if the court would want to put this on a brief hold so that, we can maybe take a look at the PC affidavit. I can also give you a summary. But not only was there an aggravated promotion of, excuse me, I'm out of breath because
No, take your
took the
time.
stairs down.
That's okay.
Not only was there an allegation that started out as a first degree aggravated promotion of prostitution that we have agreed to plead down to a lesser, but there was also an allegation that the individual or individuals who this defendant was essentially pimping were assaulted by this defendant, Judge. And I think under those circumstances, he's not. I think deferred would not be appropriate in this case.
So let me do this. Thank you for coming down, Mr. Smith. Mr. Coleman, give me just a second. I'm going to take a look at that.
And I would say that is an allegation. I'm not sure if Mr. Coleman has actually spoken with the alleged complainant. She's incarcerated, so maybe he could, or she was incarcerated as of last week.
Happy to have a sentencing hearing if the court
But
goes.
like I stated, for the reasons, there have been several types of cases where the court, for even, I would say worse offenses than this, where a person has had the opportunity with deferred probation when they do not have any prior criminal history. So we believe that that would be fair, in this situation.
Well, give me a second because y'all did agree already and
That's right, Judge.
that was what was offered and it wasn't unagreed as to the type of probation. So give me just a minute. All right, I think I'm going to go along with that original deal. Thank you for coming down, Mr. Coleman.
Thank you.
Obviously the allegations are, very serious. So let me go back and do this. Mr. Thornton, you made an agreement, for that 10-year term, and that's what we're going to go along with. And so I am again going to find sufficient evidence to find you guilty. I am at this time, in accordance with your agreement, going to find you guilty of promotion of prostitution. I'm going to sentence you in accordance with your agreement to a term of 10 years in prison, but that'll be probated. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That includes, you will initially be on the high medium caseload, which just means you'll be under a little more supervision so they can make sure you're headed in the right path. You will be required to complete the moral recognition therapy and pay the cost of that. Have absolutely no contact with Caitlin Whitsitt, and not be on the premises of 4150 Maida Road. In addition, no association or whatsoever with prostitutes in any way, whether they're willing or not. You cannot have anything to do with them. Do you understand?
Mm-hmm.
If you do everything you're supposed to, you still have an excellent opportunity because you'll be able to serve that 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you'll be brought back into court and you'll be facing that 10-year sentence that you agreed to. Do you understand?
Mm-hmm.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Thank you, Ms. Holmes. Thank you,
Thank
Mr.
you.
Coleman. Mr. Eckhart on Marshall Chance. Mr. Smith. I think I still got it up here.
Sorry, I was taking a reprimand from Mr. Coleman.
That's okay.
Never seen that man so out of breath.
All right, sir, you Marshall Chance. And Mr. Chance is here in cause number 26 DCCR 0370 and charged with aggravated assault with a deadly weapon. Mr. Gertz is the attorney. Mr. Eckhart's here for Mr. Gertz today and has filed a motion asking that I consider removing the GPS monitoring device because you're unable to get on the premises of work. Is that correct? There's an issue?
Yes, Judge. So since he's been on bond conditions, he's been on short-term leave. He is now in the process of trying to get back to work, and the facility will not let him work where he does, where his normal job duties require because he works around explosives. The GPS company, they've gone through efforts to see if the GPS company can verify the equipment as it's an industry term, intrinsically safe, meaning that it can withstand any elements that would potentially cause ignitable liquids to explode. So I think there's a lot of devices that cannot go into certain facilities because they are not deemed intrinsically safe, like cell phones and things like that. And the GPS monitoring company cannot verify that. So we're kind of at an impasse where he's either going to lose his job or we're going to have to figure out another way to monitor him.
All right, and just for the record, I am taking judicial notice of the court's file, review the probable cause affidavit as well, and that underlying offense. Mr. Smith, what's the state's position?
I don't, and I understand where they're coming from. I guess I don't have much of a position.
And Judge, just for the
I person would lose their job.
right, just for the court's.
Well, I mean, I would too. However, there's obviously the allegations are very serious. Has there been any issue that you know of? Have you heard from the complaining witness?
Not that I've heard from, not that I know of, Judge.
So here's what I want to do. I would like for you to get in touch with her prior to me ruling on this. And what I can do is we don't necessarily, if there's no issues with her and any contact, put it in an email between myself and you and Mr. Gertz. and I can make a ruling without having to come back to court, and I can do that a little quicker since we don't have a docket next Monday. If there is an issue, then obviously if we need to come back, we'll reset it just for a couple of weeks and come back and let everybody make that argument or bring her here or whatever we need to do. Okay. All right. So stay in touch with Mr. Gertz. He'll be getting an email and we'll figure that out if there's any issues, and then I'll make a will for that. Okay.
Thank you, Judge.
Yes, sir.